Moot Court competition. I really hope we get an acronym for that soon, because I always struggle getting through that on one breath. I'm Mark Valentine. I'm the coordinator of the aforementioned competition. And we greatly welcome all of you here today. We've had some very, very excellent teams compete this year. This is by far the best competition that we've had to date. It is by far the best competitors that we have had to date. In the top 16, the difference between number 16 and number 1 was only several points, if that gives you an idea. The difference between number 1 and number 4 in our final 4 was only 1 point. That gives you an idea how tight and how good these competitors are. This is the first year in 4 years that we've had to use the tiebreaker part of our rules, which means we go to look at your brief score. Whoever had the highest brief score moved forward. So it's quite an honor to host such wonderful, wonderful teams. This year we had 22 of those teams, and they did an excellent job. I also want to thank Professor Van Nostrum, and Dean McConnell, and all their hard work they've done, Professor LaFaso. The Moot Board this year has been excellent. And I'm not an optimistic person, as many of you know. And I must say that I really, really have enjoyed this year's Moot Court Board. They've done an excellent job. They never once have let me down. They've always done everything that we needed to do, and they've done a great job at it. And I think we should all give them a round of applause for that. And without further ado, I'd like to ask Josh Cottle to come forward and tell us just a little bit about the problem that we have today.
For brevity's sake, I'm going to skip reading all of the facts. You can find that in your program. However, I'll highlight the issues on appeal. The issues on appeal, this case involves Commonwealth Energy and the state of Vandalia. The case arises on two sides. The first issue involves the Clean Air Act. The other issue involves the Clean Water Act. Commonwealth is appealing the Clean Air Act issue. That issue involves whether the district court below erred in determining that the Clean Air Act does not preempt a state from bringing a common law nuisance claim against a power plant operating in another state for alleged damages resulting from emissions in an upwind state. Alternatively, related to that, if the Clean Air Act does not indeed preempt Vandalia's claim, whether the district court erred in its holding that Commonwealth Energy is liable for compensatory damages and subject to an injunction, or whether the district court's holding is otherwise an abuse of discretion. Now, the second issue in this case involves a FERC decision below. These two issues were consolidated due to like parties and like issues. And so the issue is whether FERC's determination, the Federal Energy Regulatory Commission, determination that Commonwealth's turbine replacement and intake structure alteration proposal for the Eagle Station, which is the hydroelectric station, do not require a water quality certificate under 401 of the Clean Water Act, whether that was an arbitrary, capricious, or an abuse of discretion, unsupported by substantial evidence or otherwise not in accordance with the law. Many issues will be discussed in relevance to that, and that, for its most sake, will determine deference to agency determinations, and indeed whether the agency was making a determination under the Clean Water Act or whether the agency was also making a decision under the Federal Power Act. Now, finally, in the event that the alterations or replacement would otherwise require a renewed water quality certification, whether the circumstances of Commonwealth Energy's operation of the Eagle Hydro Station on an annual license preempts Commonwealth from the requirement that it obtain a new water quality certification. Again, those are the issues on appeal. We would request that remind you to turn off your phone or put it on silent so it doesn't ring, and thank you. At this point, Dean McConnell is going to come forward and say some words.
Welcome, everyone, to the competition. I appreciate all of you being here today. For those of you who are admitted students, thank you for staying to watch. I think you'll be very excited by this. It's a wonderful day for all of us. This is an incredible competition, 4th annual. We're very pleased, and it's only possible because we have received support from the law firm of Steptoe & Johnson, and one of the partners is here with us today, Hank Lawrence. Want to wave, Hank, and Chesapeake Energy. So I want to make sure to thank them. We wouldn't be able to do this without our donors. So thank you all very much for being here, and enjoy the competition.
Hello, everyone. I'm Ann LaFaso. I'm the Associate Dean for Faculty Research and Development. I'm a professor here of Labor Law and Employment Law, and I'm also the Faculty Advisor for the Moot Court Board. This year, we've had an outstanding group of students who have put this on, and I just want the organizers of this event, they organized several events. The organizers of this event, I just would like you to stand when I call your name. Kelly Gans, Chief Justice. Mark Valentine, the coordinator, who is not a student. He's a former student. He did graduate, and he used to be, okay. Stand up, please. Josh Cottle, the Associate Justice for Energy. Jeremy Gunn and Paul Robinson, who are both the energy chairs, and Adam Strider, our judge liaison. These young people have worked very hard to put this on, and please help me give them a round of applause. I'd also personally like to thank Joyce McConnell for everything she does for the school. She's an incredible leader. I call her Miracle McConnell because she does so many wonderful things. And afterward, at the reception, you should all try to meet her, talk to her. She's really the best dean in the entire country. I'd like to thank Professor Van Ostrin for everything he does to lead the Energy Center, and also all the other people that work for you, I'm sure helped with this problem, and whose work is invisible, but if we can also just thank those people. I also would like to introduce to you our finalists. Representing, because I just met them. So representing the Commonwealth Energy this is the team from, we're going to tell you who they are, but we don't tell the judges, okay? So, of course, you won't have an opportunity, but we're going to now announce this, okay? So this team is from North Dakota, and they are Jesse Meyer and Kendra Olson. Jesse is recently engaged. He hails from North Dakota. He's recently engaged, but his fiancée, who is a school teacher, couldn't be here because she's very busy. And Kendra hails from Minnesota, and she is a former high school teacher. So please help me welcome North Dakota and congratulate them. On this side, representing the Commonwealth, the state of Vandalia, is the representing Duquesne, who's been in the finals or semifinals just about every year, so they have a wonderful tradition now. And we have here David Leak and Alexandra Koselko. Koselko? Oh, I did it wrong, didn't I? What is it? Koselko. I did it wrong again. I'm so sorry. I'm nervous. And they're both from Pennsylvania. And they said they're both executive board members of the Moot Court Board, and they just live, breathe, and do everything Moot Court. So please help me welcome them and congratulate them. We have put together a wonderful panel of judges. You'll see as they come out from most junior to least junior, it will be Larry Rosenberg, and he's a partner at Jones Day. He's a partner at Jones Day, which is a large international firm, and he is also the professor. He's a professor here, and he teaches in our Supreme Court clinic, and we're one of the few schools in the country that has a United States Supreme Court clinic. The other four are judges, either in the Court of Appeals or in the District Court. Sitting next to Larry will be the Honorable Stephanie Thacker of the Fourth Circuit. The Chief Justice for today will be the Honorable Michael Fisher from the Third Circuit. Then next to Judge Fisher will be the Honorable Frederick Stamp from the Northern District of West Virginia. And then to his right will be the Honorable Irene Keeley, and she's also a judge in the Northern District of West Virginia. So those are my introductions. This is going to be exciting, and let's just, I guess we should start. How are we going to do it?
Yep. All rise. Oyez, oyez, oyez. All persons having business before this honorable court are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. See, before we get started today, I would like to introduce the panel who will hear this argument today. And first of all, I am Judge Mike Fisher, and I sit on the U.S. Court of Appeals for the Third Circuit, which geographically is just north of here. To my left is the Honorable Stephanie D. Thacker of the U.S. Court of Appeals for the Fourth Circuit, in which West Virginia is located. To her left is the Honorable for the day, Lawrence D. Rosenberg, who is a partner at Jones Day in Washington, D.C., and an adjunct professor here at the West Virginia University College of Law. To my right is the Honorable Frederick P. Stamp, who's a senior U.S. District Judge for the U.S. District Court for the Northern District of West Virginia. And Judge Stamp sits in Wheeling. And to his right is the Honorable Irene M. Keeley of the U.S. District Judge for the U.S. District Court, also of the Northern District of West Virginia. So that is our assembled panel here this afternoon. We understand that the two appeals that are before us, we're looking forward to hearing the finals of this fourth annual National Energy and Sustainability Moot Court competition. We know all of you have done excellent work to get here as of this point, and we look forward to your arguments. And we understand that for the first part of the case, since we have two appeals here, that the Commonwealth Energy will be arguing first. And for that, we recognize Commonwealth Energy.
Thank you, Mr. Chief Justice, Counsel, and may it please the Court. Your Honors, my name is Jesse Meyer. Together with Kendra Olson, we are representing Commonwealth Energy, CE, the petitioner in this portion of the consolidated case. Your Honors, at the outset, we would request 2 minutes of time for rebuttal, 1 minute of each to be deducted from our respective times.
That request will be granted.
Thank you, Mr. Chief Justice. I'm here today to address two issues with the Court. First, whether the lower court erred in determining that the Clean Air Act did not preempt the state common law nuisance claim. And second, whether the lower court erred in holding CE liable for compensatory damages and subjecting CE to an injunction. My partner, Ms. Olson, will be addressing the remaining issues with this Court as to the FERC's determination as to the new water quality certification of CE. Your Honors, there are three reasons why the lower courts erred in their decisions in this case. First, the lower court erred in ruling the Clean Air Act did not preempt the state common law nuisance claim because the nuisance claim frustrates the goals and purposes of the Federal Act and must be preempted to the extent of that therein. Second, Your Honors, the lower court erred in holding CE liable for compensatory damages and subjecting CE to the extreme remedy of an injunction because CE's conduct was in strict conformance of the Clean Air Act and corresponding state agency, and obeyance of both federal and state law is inherently reasonable under Franklin's standard of nuisance. And finally, Your Honors, the lower court erred in subjecting CE to the extreme remedy of an injunction because there are alternative, unexhausted legal remedies available sufficient to address the state's concerns, and an injunction is unwarranted due to the hardship it would place on both CE and the people of Franklin and Vandalia. Now, as to the preemption question, Your Honors, pursuant to Supreme Court precedent, namely Chevron USA Incorporated v. National Resource Defense Council, this court must review a matter of statutory interpretation de novo with no deference to the lower court's decisions. In Retail Clerks Intern Association, Local 1625 v. Schermerhorn, the Supreme Court stated that the purpose of Congress is the ultimate touchstone in every preemption case.
Are you arguing field preemption, conflict preemption, or both?
CE is arguing, Your Honors, conflict preemption.
Then what is the specific policy with which you claim there is a conflict?
Yes, Your Honor. Pursuant to Supreme Court Precedent, Pacific Gas and Electric Company v. State Energy Conservation Commission, an area of state law, public nuisance in this case, will be preempted to the extent it frustrates the goals or purposes of the Federal Act. Now, the goals and purposes of the Clean Air Act are stated at 42 U.S.C. Section 7401B1, in which one goal of the Clean Air Act is to create a national uniform reduction of emissions so as to promote and protect the public health, welfare, and productive capacity of the population.
So how does this public nuisance suit disrupt that goal?
Your Honors, if nuisance is allowed to continue in this case, it will allow for a direct conflict Your Honors, will allow for a direct conflict with the Clean Air Act by forcing parties to waste time and energy grappling with these vague and indeterminate standards.
Okay, so I mean, how is that much different than having repetitive administrative actions that might come that a company like yours could also say waste our time and energy?
Your Honors, the Clean Air Act has already set standards of which to follow. And certainly there's similarities between an administrative hearing's repetition and a nuisance law wasting time. However, Your Honors, in an administrative hearing, there is an end. There is a conclusion to the case. In the present case, if nuisance is allowed to continue, that sets precedent for this circuit, that nuisance laws will always be allowed to continue. And, Your Honors, we are not arguing today that all common law or all nuisance is preempted. Just the nuisance law in this case, because it conflicts with this Clean Air Act standards.
Why isn't Willett versus International paper dispositive in this case? And if you don't think it is, why isn't it?
Your Honor, the International paper via Willett is not dispositive in this case because, first, the International paper via Willett determined or examined the savings clauses contained in the Clean Water Act and determined that a nuisance claim could proceed pursuant to the laws of the source state. Your Honor, in the present case, it is the Clean Air Act we are examining.
Is there any difference in that savings clause and the savings clauses between those two acts?
Your Honors, the Supreme Court has held in the City of Milwaukee v. Michigan and Illinois that the savings clauses between the two acts, the Clean Water Act and the Clean Air Act, are nearly identical. However,
so how does the fact that this is under the Clean Air Act, that's under the Clean Water Act, how does that make this case different?
Your Honors, it makes it different because although the explicit language or the text of the statutes are the same, they are designed to address two different things. The Clean Water Act is designed to address water pollution or water emittance, which are much easier or much more readily available to track, whereas the Clean Air Act is designed to address amorphous or changing conditions where pollution can cross interstate lines quite easily.
Didn't Congress specifically contemplate a nuisance claim when it included a savings clause in the Act?
Yes, Your Honor. Pursuant to 42 U.S.C. Section 7406E, the Clean Air Act states that nothing in this section shall restrict any right which any person or class of persons may have under any statute, common law, or seek any other relief. However, Your Honors, this statute is caveated by the fact that a common law claim cannot frustrate the goals or purposes of a federal act. And in the present case, that's exactly what the nuisance claim does.
So you've said that Clean Air Act and Clean Water Act, same language, different context. Why is uniformity, which sounds like the policy that you're arguing for, so much more important under the Clean Air Act than the Clean Water Act? Both are dealing with things that are transmissible across state lines. So explain that to me.
Your Honor, the uniformity concern that CE has in this case is comes precisely from 42 U.S.C. Section 7401B1, which a national uniform reduction of emissions is the main goal of the Clean Air Act. Further, and pursuant to Pacific Gas and Electric Company, the State Energy Conservation Commission, the test of preemption is whether the matter on which the state asserts the right to act is in any way regulated by the federal government. Your Honors, in North Carolina, Ex Rel. Cooper v. Tennessee Valley Authority, the Fourth Circuit was faced with similar issues. And in the case, the court stated that the Clean Air Act represents decades of thought by legislative bodies and agencies seeking to press upon them a variety of air pollution policies. They further...
But wasn't the key to that case which state law was applied? In other words, they applied North Carolina's state law versus the state law in Tennessee.
Yes, Your Honor, that is correct. The express holding of North Carolina Ex Rel. Cooper was that the wrong affected state pursuant Your Honor, the nuisance law was pursuant to the affected state as opposed to the source state. Yes, Your Honor. However, these cautions or persuasive authority rings even more true in this case, Your Honor, because in Cooper, the court further stated that the role of the states has been made clear, where Congress has chosen to grant the states an extensive role under the Clean Air Act's regulatory regime through field and conflict preemption principles caution, at a minimum, against according states a wholly different role, allowing nuisance law to contradict joint and federal rules so meticulously drafted. Your Honors, in Cooper, the court chose to defer to the meticulously researched, drafted, and implemented federal act, as opposed to the vague and indeterminate standards under public nuisance, which the court stated were at such a level of generality as to provide almost no meaningful standard of application.
The federal government hasn't filed a brief in this case, is that correct?
Yes, Your Honor, that is correct.
Should we hold our decision in abeyance and ask the Solicitor General to express the federal government's views in this case?
Your Honor, CE would suggest that that's not necessary in this case. The Clean Air Act clearly contemplates that it is private actors and states that are the primary people primarily responsible for Clean Air Act or the Clean Air Act emissions. However, Your Honor, the federal court, Your Honors, the federal Congress or the federal legislature has made clear that although thank you, Mr. Chief Justice. They have made clear that common law claims are allowed to proceed, but of course this is caveated by a Supreme Court precedent that says otherwise in a conflict preemption.
What are the regulations under the Clean Air Act that you rely on to demonstrate to us that the field has been preempted, that even though private suits may be allowed or even a public nuisance suit may be allowed, it ought not to be under the Clean Air Act in this case?
Your Honor, to reiterate, CE is not arguing a field preemption.
Sounded like you are.
No, Your Honor. Respectfully, we are arguing, CE is arguing, that there is a conflict preemption issue in this case, and that the nuisance claim in this case is frustrating the goal or purposes of the Clean Air Act.
But is that because there's a regulatory scheme in place under the Clean Air Act that would suggest Congress, because of the way it's been regulated, that Congress did not intend that a public nuisance suit like this should be allowed?
Yes, Your Honor. The Clean Air Act sets standards through the state implementation programs and define particular amounts and types of emissions which are allowable. Your Honor, the whole point, Your Honors, the whole point of the Clean Air Act is to create a nationally uniform reduction of emissions with foreseeable standards and across-the-board emission regulation. Your Honors, with this nuisance, there is no standard other than reasonableness and common rights.
Now, I know we're not bound by it because it's from the Third Circuit, but how does this case really differ from Bell v. Cheswick, a case that was just recently decided by the Third Circuit?
Yes, Mr. Chief Justice. Bell v. Cheswick from the Third Circuit was a Your Honor, was a case involving property owners who were suing based on a nuisance claim. So in that regard, it is similar to this case. And that claim was allowed to proceed. However, Your Honors, in Bell v. Cheswick, the Third Circuit didn't directly address the issue of conflict preemption. Now, Your Honors, they would certainly have had to address that in order to let the claim proceed, but the opinion does not suggest or pose any evidence on
So
which...
you're saying it was wrongly decided?
Certainly not, Your Honor. However, I am suggesting that the...
Oh, you could say that. We're not bound by it.
That's correct, Your Honor. But, no, excuse me for a second. Your Honor, in Bell v. Cheswick, the Court simply did not, in the opinion, include any details as to conflict preemption. And so in that regard, it is left for this Court to assume, if they so choose to follow this case, that the claim must not have conflicted with the Federal Clean Air Act in that case. However, Your Honors, that is simply not the case in the present case today, because the nuisance claim in this case is so vague and general as to provide no meaningful guidance to commercial entities in trying to create this national uniform reduction of emissions while increasing the productive capacity of the nations. It infuses even more ambiguity in emission standards and even more litigation in the courtrooms. And, Your Honors, because this nuisance claim frustrates the goals or purposes previously described, CE respectfully request this Court reverse to the extent it frustrates these goals.
Are you here to argue the compensatory damage and injunction matter as well?
Yes, I am, Your Honor.
With the Chief Justice's permission, do you want to just take a minute and touch on that?
Yes, Your Honor. Thank you. And may I do...
Sure.
Thank you, Mr. Chief Justice. Alternatively, Your Honors, even if this Court affirms the ruling of the lower court as to the preemption issue, this Court should reverse the ruling of the lower court's decision because CE's conduct was in strict conformance of the Clean Air Act and corresponding state agency. Furthermore, Your Honors, an injunction is unwarranted in this case because under Supreme Court precedent, namely eBay v. Merck Exchange, an injunction cannot be granted unless there is no alternative legal remedies available sufficient to address the injury. Your Honors, in the present case, Section 126 of the Clean Air Act provides protections for states that believe they are suffering from improper interstate pollution. And until a Section 126 petition is filed, an injunction, it is an abuse of discretion and an erroneous conclusion of law for the lower court to have granted an injunction in this case.
So your argument is your argument that as a matter of law, there is no right to an injunction, or that injunction relief is premature because the lower court would have to hear on damages?
I see I'm out of time. May I briefly respond to your question?
You may answer the question.
Thank you. Your Honor, at this point in the litigation, it would seem that the filing of it for an injunction or the request for an injunction by the court would be premature because, as Supreme Court stated in eBay v. Merck Exchange, to be granted an injunction, there must not be any alternative legal remedies available sufficient to address the injury. So in this case, it would at least be premature until that Section 126 petition is filed. And CE respectfully requests this Court to reverse the rulings of the lower court. Thank you.
We'll have you back on rebuttal. Counsel for Vandalia, is that how you're going to proceed? Or are you going to proceed? We were told you were going to argue, and then they would argue the second part of the case.
If that's how Your Honor would like to.
I think that'd be best.
Absolutely.
Is that Mr. Leake?
Yes. Mr. Chief Judge, and may it please the Court, my name is David Leake, and I, along with my co-counsel, Alexandra Koselko, represent the state of Vandalia. Today I will discuss issues 1 and 2, which involve the Clean Air Act, and afterwards my co-counsel will discuss issues 3 and 4, which involve the Clean Water Act. Your Honors, this case is about the state of Vandalia attempting to protect its citizens and its property from harmful pollution emanating from Commonwealth Energy's coal-fired power stations. First, I will address issue 1 and discuss why the district court was correct in holding that Vandalia's public nuisance claim is not preempted by the Clean Air Act. Afterwards, I will discuss issue 2 and describe why the district court was correct in awarding injunctive relief and compensatory damages. Lastly, I will request this honorable court affirm the decision of the district court. The first issue involves preemption. The Supreme Court has held that in analyzing preemption issues, the lower courts are to start with the assumption that the intent of Congress is or that the intent of Congress, or Congress's intent shall not be to supersede the power of the states unless that's the clear and manifest intent within the Act. Your Honors, in the Clean Air Act, under Section 7401, which opposing counsel relies heavily on, and this section is called the Congressional Findings and Declaration of Purpose, it states that Congress's intent in enacting the Clean Air Act is to promote cooperation between federal and state actions in curbing air pollution. Therefore, Congress anticipated the states have great power in curbing air pollution under the Clean Air Act.
How do the states going into court independently, how does that further cooperation?
Your Honor, it furthers the cooperation in the sense that it gives the state the power to bring a legal action in order to rectify damage from air pollution in its borders. And Congress anticipated this exact situation in the two savings clauses it included in the Clean Air Act. Under Section 760...
But isn't there a process, it's referred to in your briefs, a process by which the state could bring the alleged violations to the attention of the federal agencies, and the federal agencies then would take the appropriate action under the Clean Air Act? Doesn't Congress indicate a preference for that level of cooperation rather than the parties independently running into the courts?
Yes, Your Honor. While Congress did include this petition process, which is referred to as the 126 petition under the Clean Air Act, this is one avenue in order for a state to seek relief, but it's not the only avenue. And Congress included in the Act itself that the Clean Air Act shall not restrict any person or group of persons' right to seek common law relief under Section 7604E. So while Congress did intend...
But isn't that, in essence, a private nuisance case as opposed to a public nuisance case brought by your client?
No, Your Honor, for two reasons. First, if I could point the Court's attention to two sections before that in Section 7602, the Clean Air Act specifically includes within the definition of person, state or political subdivision of a state. Additionally, the Supreme Court has held that this very provision applies to a state suing in a Supreme Court opinion as well.
I'm going to ask the same question I asked your opponent. Given all of this, shouldn't we hear from the federal government before rendering a decision?
No, Your Honor, because under the Clean Air Act itself, that's not necessary in this present case. The Clean Air Act, while it includes that savings clause that I mentioned about the citizen suit, and a state is defined as a person under the Act. Additionally, there's another savings clause, Section 7416, and that savings clause states that a state may adopt clean air standards and to curb pollution, and these standards may be stricter than those found in the Clean Air Act itself. In the present case, Franklin law, which was applied by the district court, may arguably be stricter than that of the Clean Air Act. It's still authorized under the savings clause, and therefore the plain language of the Clean Air Act allows the common law claim to proceed. As on page 9 of the record, the district court itself stated that Vandalia's claim was anticipated by Congress in including these two provisions.
The Bell case pointed out specifically that there were two savings clauses relative to this Act, one being the citizen suit savings clause and the other being the retention of state authority savings clause. Which one applies, or do both apply, or how do we reconcile those two if necessary?
Yes, Your Honor, they both apply. The citizen suit savings clause specifically allows the legal action that Vandalia took in the present case because it's a common law action that's allowed under that savings clause, and the district court's application of law is allowed by the second savings clause, the state's rights retention savings clause, because it allows a state to adopt standards for pollution, and those standards may be stricter. Additionally, federal courts universally accept that the Clean Air Act does not preempt source state common law claims. In 1987, the Supreme Court was faced with this very preemption issue involving the Clean Water Act in the International Paper versus Ouellette decision. Now, in that decision, the Supreme Court held that source state common law claims are not preempted by the Clean Air Act. While that did involve the Clean Water Act, that holding has been applied to the Clean Air Act universally. In fact, on remand in Ouellette, the district court applied the holding to the Clean Air Act portions of the case. And since then, the Third, Fourth, and Sixth Circuit, as recently as August of 2013, and Bell versus Cheswick Power Station, have applied the OLET holding to the Clean Air Act. Now, in the present case, Raven Station is located in Franklin, and the district court, as evidenced on page 9 of the record, applied Franklin law. Therefore, Franklin is the source state in the present case. And since Franklin law was applied in the present case, this long line of federal court cases that culminate in the Bell decision in August 2013 all indicate that the common law claim is not preempted. In fact, on page 190 of the Bell decision, the court found that the savings clauses taken together with OLET indicate that these types of claims are not preempted, and specifically stated if Congress intended, and Congress's intent is the main factor, if Congress intended these type of claims to be preempted, it would have done so in the Act, and its failure to do so is would be spectacularly odd.
But what about what the Supreme Court said in North Carolina? It seems to me in North Carolina you can argue it a couple of different ways, but the facts are very similar to this case.
Yes,
neighboring states, pollution in one state bringing suit, and they struck that down. How do you distinguish North Carolina from the facts here?
Your Honor, the facts in North Carolina are very similar, and North Carolina's ultimate holding is applicable in this case. On page 306 of the North Carolina opinion, the court specifically held that OLET applies, and source state common law claims are preempted by the Clean Air Act. In that case, the state of North Carolina brought a cause of action against TVA, a private entity that owned power stations in Tennessee and Alabama. And the court's ultimate holding is that the affected state common law was actually applied, and therefore it was a misapplication of OLET. Therefore, that case is actually in line with the Bell opinion, the ultimate holding is. And following Bell and Tennessee Valley, the source state common law claim is not preempted by the Clean Air Act in the present case. The Bell decision also used reasoning from OLET and reasoning this court should apply, and that while Commonwealth Energy may argue that allowing a nuisance claim to move forward would lead to less predictability of regulation because of vague standards, the Bell court adopted OLET and actually rejected the Power Companies Council argument to that, stating that allowing a source state common law claim to proceed would not lead to less predictability of environmental regulation in the power sector because the power company would only have to be in compliance with the state's law that is geographically located, and that law is predictable. And therefore, we ask that this court look to the Bell court and the Tennessee Valley in that regard.
Judge Stamp asked about the damages question, so that you don't run out of time. Do you want to address that at all?
Yes, Your Honor. The injunctive relief and compensatory damages, the award by the district court was proper for two reasons. First, I'll address the injunctive relief. Injunctions have been used since the 16th century by the court to abate public nuisances, and the United States Supreme Court said that in United Steelworkers versus U.S. in 1959. Under an award of injunctive relief is viewed under an abuse of discretion standard. The Supreme Court has held that under this standard, the district court's holding should not be overturned, but for a clear error of judgment on the part of the trial judge.
But wasn't the injunction here premature?
In the present case, Your Honor, the injunction was not premature. Franklin has adopted the Restatement Second tort formulation of public nuisance, and under that formulation, a balancing test is used to determine whether an injunction is proper. Now, that balancing test, the most important factor is if the injunction will halt irreparable harm. In the present case, Vandalia offered evidence in the form of expert testimony, DEP records, and Board of Tourism records that specifically showed that since 2009, when Raven Station began operating in a dirtier manner, national ambient air quality standards began to fall in Vandalia. And with that, brought damage to private and public property, damage to the economy, tourism.
But isn't your opponent's argument that there are two alternative remedies, right? One's money damages. Maybe that's not fully sufficient. But the other is that other technology could abate the problem created by the pollution, and you didn't have to actually enjoin anything to get the air healthier, right?
Yes, Your Honor. The Commonwealth Energy argues that the Clean Air Act provides a better remedy in that it gives the EPA, in a sense, an equitable power to force a polluter to install additional emission controls. In the present case, equitable remedy will not rectify the damage. And under the Clean Air Act, legal remedy, there's no source of legal remedy under the Clean Air Act.
Okay. I was just going to say, what is the state of the record? Is there evidence in the record, expert evidence, for example, that says that this additional use of technology wouldn't clean the air sufficiently? And if there isn't, shouldn't we remand for that record to be made?
Your Honor, if I understand your question correctly, there's nothing in the record that says, while the record reflects that the injunction will, in essence, stop the pollution and bring Raven Station in compliance with national ambient air quality standards, and the trial court awarded that, weighing all of the facts and applying the law, and the trial court came to the conclusion that that injunction will halt the pollution.
Right, my question is there evidence in the record showing that an alternative use of technology, apart from the injunction, would be unable to clean the air sufficiently?
No, Your Honor. The record is completely silent as to that issue.
Right. And given that there's an alternative remedy that might work and there's no evidence on it, shouldn't we remand to have that record developed before permitting the injunction to proceed?
No, Your Honor, because the district court took all of the factors into account in making its holding with the injunction, and if there was an alternative remedy, it can be assumed that the district court would have taken that into account. While we don't have the entire transcript in front of us, the district court's award of injunctive relief should not be overturned but for an abuse of discretion, and that would require a clear error of judgment on the part of the trial judge. And in the present case, there is not a clear error of judgment.
Did the district court go through all of the elements for granting an injunction under the Supreme Court case in Winter? Did they go through irreparable harm and the balancing and the public interest? Did they go through all of those? Or do we have a record finding of that?
Your Honor, the record is silent on that issue, but the ultimate holding of the court was that there was a public nuisance, and while the balancing test may not have been applied in the record, it would be assumed that if that was not applied, that would be a clear error of judgment on the part of the trial judge. But that trial judge is to be given every benefit of every doubt under the Supreme Court precedent. Additionally, the Clean Air Act does not provide compensatory damages which will rectify the past harm. So the compensatory damages for the past harm in Vandalia are necessary, and the injunction is necessary to halt the future harm. For these reasons, we ask this court affirm the district court.
Well, if we don't have a record information, sort of picking up on Justice Rosenberg's point, we don't have a record that they went through all the elements under Winter. How do we know that they were right, the district court was right or wrong, and don't you have to remand or set it down for oral argument sometime in the future before this court to get that? It seems to me that's a pretty key issue on the injunction.
Your Honor, this would not be necessary in the present case because under the standard, this high standard, the trial court is given every benefit of every doubt. And
on both the legal and the factual issues?
Excuse me, Your Honor?
On both the legal and the factual issues?
No, only on the factual issues, and the award of injunctive relief and compensatory damages as well get a abuse of discretion.
But if the trial court failed to consider one or more of the factors, wouldn't it be a legal error?
I see that my time has run. May I answer your question?
Oh, that would be good for you. Yes, please.
Okay. Yes, Your Honor. If it was a conclusion of law that was at issue, and it's not, that would be a de novo standard, and this court could substitute its judgment. But even doing so, there was proper application of law, and therefore this court should affirm. Thank you.
Thank you. Mr. Mayor, do you want to come back on rebuttal? I believe you reserved a minute.
Yes, Mr. Chief Justice. I will be brief, thank you, and may it please the Court. Your Honors, Franklin's own nuisance standard is adopted from the Second Restatement of Torts, which further states that conduct that is authorized by statute, ordinance, or administrative regulation does not subject the actor to tort liability. Your Honors, an injunction is also unwarranted in this case due to the hardship it would place on CE. According to the record at page 9, it would cost as much as $250 million to be required to install the technology required under the injunction. And it would be an extreme obligation to force CE to incur a $250 million cost for engaging in conduct that is
Aren't
frankly...
they going to just pass that on to the ratepayers?
It would certainly be reasonable to assume that, yes, they would, Your Honor.
But isn't that part of the harm here, that the ratepayers, particularly the commercial ratepayers, will be disparately affected with a higher rate, even though the overall rate might be 3%?
Your Honor, I see I'm out of time. May I briefly answer your question?
You may answer that question.
Thank you, Mr. Chief Justice. Yes, Your Honor, the harm doesn't stop with the injunction because the state of Vandalia or the people of Vandalia who are claiming the injury in this case are going to be even further injured by an injunction in this case. Thank you for your time, Your Honors.
All right, we'll hear from, on behalf of Vandalia on the second appeal, we'll hear from Ms. Kakelka.
Good afternoon, and may it please the Court. My name is Alexandra Caselco, and I also represent the state of Vandalia. As my co-counsel mentioned, I will now address why the Federal Energy Regulatory Commission's determination that no water quality certification was needed in this matter was incorrect. The first issue under the Clean Water Act is whether the proposed modifications to the Eagle Hydro Station require a new water quality certification. This Court should reject FERC's finding for two reasons. First, these proposed modifications constitute a discharge as contemplated under Section 401A1 of the Clean Water Act.
Do we owe Chevron deference to FERC's findings in this case?
Your Honor, there are two separate standards at issue here. First, FERC's interpretation of what is a discharge under the Clean Water Act is not owed Chevron deference because the EPA, not FERC, is the agency charged with administering the Clean Water Act.
Can't multiple agencies administer the same statute?
Your Honor, the D.C. Circuit in the Alabama Rivers Alliance versus FERC case found that it is the EPA, not FERC, which is given Chevron deference. However, turning to the material adverse impact test, which I will also address, in that matter, FERC is given Chevron deference because they are the agency charged with administering the Federal Power Act, which that regulation is promulgated under.
Well, doesn't FERC have the right to interpret the Clean Water Act when it comes to hydro power licensing, and isn't that what this case is all about?
Your Honor, FERC does have the power to issue those licenses, but they do not have the power to interpret the Clean Water Act. It is merely the EPA itself which is charged with administering that act, and only the EPA which deserves the deference of this Court in interpreting that act.
Is there any case law that bifurcates those levels of deference between agencies that you can point to?
Not specifically, Your Honor, but lower courts that have examined the issue of a discharge have not given deference to FERC's interpretation of what constitutes.
Has anybody said, per se, in an appellate court or the Supreme Court, have they ever said that where there was, like Judge Keeley mentioned, because hydroelectric power comes under FERC, that they would have, that we should defer to their interpretation under the Clean Water Act?
No, Your Honor, and that's because it is, in terms of the environmental considerations regarding the licensing and the operation of hydroelectric plants, it is certainly the EPA that has the expertise in these environmental issues.
But there's been, in the record, does it say that there will be an increase in the flow of the water that would arguably put this within the jurisdiction of the EPA?
Your Honor.
There's no discharge, is there?
There is absolutely a discharge in this matter, Your Honor. Though there is not.
Was that where you think the agency was wrong as a matter of law or as a matter of fact?
As a matter of law, and the interpretation that only an increase in the rate and flow would be sufficient to constitute a discharge. The Supreme Court in 2006, in the S.D. Warren Company case, specifically kept the term discharge as broad as possible when defining that term in order to preserve state authority. There, the Court held that the term discharge had its ordinary and plain meaning, namely the flowing or issuing out of. The Court kept.
But I don't mean to interrupt, but if there's a decrease, which is, I thought, what the record reflected here, in the discharge, the volume of discharge through the dam turbines, why why is that a discharge that's regulated by the EPA, if it's a decrease?
Your Honor, the record showed that it was, on page 11, if I could point, Your Honor, that it is the same rate and flow as the water that is currently coming out of the Eagle Hydro Station. The discharge is not triggered by the rate and flow, but rather by the addition of more cold water to the Winnipenny River and the addition of water that has a lower dissolved oxygen content. That water
That's going to be corrected, isn't it? The lower dissolved oxygen content is going to be corrected with the aerators, right, that are proposed by CE?
Yes. Commonwealth Energy asserted that the aerators currently in place would be able to reoxygenate the water to its previous levels. However, it was FERC's finding not that it would be identical, but rather that the dissolved oxygen content would not exceed the 5 milligrams per liter requirement under the original water quality certification. The fact that there would be some difference, or that there is a possibility that there could be some difference in the dissolved oxygen content, is sufficient to trigger the statutory requirement of a new water quality certification.
Putting that aside, would a change in temperature alone be sufficient to equate to a discharge in your view?
In this matter, yes, Your Honor, because it is the addition of more cold water to the Winnipenny River. And the D.C. Circuit in the state of...
I thought you said the flow wouldn't change, it's just the temperature.
Yes, Your Honor. The flow would not change, but what is being added to the Winnipenny River absolutely would change, because it will decrease the average temperature of the Winnipenny River from what was previously 70 degrees to now between 60 and 62 degrees.
But that doesn't...
Does case law support that a change in temperature alone would be sufficient?
Your Honor, there is no case that has investigated whether a change in temperature alone would be sufficient, but if I could point this Court's attention to the S.D. Warren case from the Supreme Court, there the Court specifically looked at temperature change and the effect this would have on water quality. And though the circumstances of that case were an increase in temperature, it is presumed that a decrease in temperature of between 8 to 10 degrees here would be sufficient to trigger this requirement, because the Court specifically kept the term discharge so broad as possible in order to ensure that states are given their statutorily given right to regulate water quality by issuing the state certification. Additionally, Your Honors, the D.C. Circuit, which has looked at the term discharge in the state of North Carolina versus FERC, as well as the Alabama Rivers Alliance versus FERC case, have looked at the term discharge contemplates the addition of something. And because here there is the addition of that colder water, and the addition of water that may have a different dissolved oxygen content, this is sufficient to trigger the discharge water quality certification requirements.
Didn't the D.C. Circuit, though, in the state of North Carolina case, give deference to FERC in a very similar factual context?
The facts of that case are distinguishable, Your Honor, because there is actually a decrease in the flow of water coming out as a result of withdrawing the water from a different portion of the lake. Here, the rate and flow will remain the same, but we will also have the addition of dissolved oxygen content. And because both the Supreme Court itself as well as lower courts have recognized the immediate harm that lower dissolved oxygen levels could have on wildlife populations, this is a matter that would trigger a water quality certification requirement. And the language of Section 401A1 states that it is any activity that may result in any discharge that triggers the state certification requirement.
Is the key to your argument not that we shouldn't focus on the fact that there will be no increase, but rather that the dissolved oxygen content and the change in temperature will occur even though the change in temperature is not above what's allowed and the dissolved oxygen content will be corrected by aerators?
Yes, Your Honor. This change in the temperature and a possible change in dissolved oxygen content are sufficient to trigger a state certification requirement. Additionally, there is nothing in the record to indicate that Vandalia intends to deny this water quality certification, but rather it is merely seeking to assert any power to regulate the water quality. And it is only through the issuance of the water quality certification and setting the requirements of that certification that Vandalia is able to have any input at all on the water quality in the Winnipenny region.
So what is Vandalia's position with regard to Chevron findings and deference?
Your Honor, it is Vandalia's position that the interpretation of a discharge and the term discharge under the Clean Water Act should be reviewed de novo by this Court. However, turning to the material adverse impact test, Vandalia acknowledges that as FERC is the agency charged with administering the Federal Power Act, this Court should give deference to their determination. However, This court can absolutely overturn FERC's finding if they were arbitrary and capricious and they did not investigate substantial evidence and make a reasoned conclusion from the evidence that they saw.
What makes that arbitrary and capricious from the lower courts?
Your Honor, what makes it arbitrary and capricious in this matter is that FERC simply rubber-stamped all of Commonwealth Energy's assertions in this matter and did not conduct any independent investigation or require any testing at all looking at the effects that these changes would have on the Winnipenny River. Your Honors, in the Alabama Rivers Alliance versus FERC case, the company there alleged that there would be no change in the dissolved oxygen content or that it would not be an issue, and FERC required regular testing as a result of those modifications to ensure that the dissolved oxygen content would in fact remain the same and not be materially adverse to the water quality.
But you intervened, and didn't you offer? Did you offer any evidence on those questions?
Your Honor, the record reflects that Vandalia expressed its concerns regarding the dissolved oxygen levels and the temperature difference, and that FERC heard those concerns but still came to the conclusion that there was not a material adverse impact. FERC came to this conclusion by seeing that there would be some benefit to the salmonoid population of fish in the Winnipenny region. However, the presence of one benefit is not sufficient to say that no water quality certification is needed. The regulation itself, as promulgated by FERC, states that if a license amendment would result in a material adverse impact on water quality, then a new state certification is needed. And here, because there would be a material adverse impact on the water quality as a result of this lower temperature and different dissolved oxygen content,
What would the material adverse impact be?
Your Honor, if we look first at the temperature here, if I could point Your Honors to page 6 of the record, FERC specifically took note of the fact that the Winnipenny region attracts thousands of tourists every summer because it is known for its warm and swiftly flowing waters. And as noted in the record through Vandalia's anti-degradation policies, it accepts the use of all of the designated uses of the Winnipenny region. And one of those uses includes recreation such as swimming, boating, and fishing.
But those concerns were expressed to FERC, right? By you.
Yes, Your Honor.
And they said, good for salmon, maybe a little less good for swimming. We're going to go with the fish.
Yes, Your Honor, but that was an incorrect interpretation of the agency's own regulation that a material adverse impact would require a state certification. Additionally, Vandalia was able to express concerns before FERC, but the process of obtaining a new water quality certification, through there, Vandalia would be able to conduct independent testing and investigate the matter as to whether there would in fact be a material adverse impact on the water quality and ensure that any of...
But you could have done that already, right, and submitted all that evidence to FERC when you intervened.
Vandalia could have done so, Your Honor. However, there's no reason that FERC absolutely has to take Vandalia's concerns into effect when coming to this conclusion. And that is why the state should be able to exercise its statutory given right in order to issue a state water quality certification in this matter.
I guess a difficult job any judge has or any court has isn't FERC in a better position to evaluate these technical questions than we are as jurists?
Your Honor, in terms of the licensing or the operation of the hydroelectric plant, in those regards, FERC is absolutely in the best position to analyze those issues. But when it comes to environmental issues, the State Department of Environmental Protection or the EPA would be a much better venue to address these environmental concerns because it is those agencies and those departments which regularly deal with the environmental issues as opposed to the operation or the licensing of the hydroelectric plants. Turning now to the second issue under the Clean Water Act, the operation on an annual license basis does not preempt the need for state water quality certification. This court should reject FERC's finding of imposing interim conditions on an annual license as a means to get around the water quality certification requirement. The purpose of an annual license is to be a stopgap.
And aren't they basically saying this is just a continuation of the license that's in place until we resolve this matter?
Your Honor, it is not a continuation of the license currently in place because an annual license is to be granted on the exact terms of the original license. And here, in July of 2013, FERC imposed interim conditions which would permit Commonwealth Energy to do a full-scale replacement of Turbine 1, as well as modify the intake structure to draw water from a deeper depth, water that is 15 degrees colder, and water that has that lower dissolved oxygen content. So the annual license stops being that stopgap measure the minute that these interim conditions, which imply drastic changes to the operation of the station, are applied in this case.
Doesn't FERC's own regulations permit it to incorporate additional or revised interim conditions if necessary and practical to limit adverse impacts on the environment, and I'm referring to 18 CFR 1618D.
Yes, Your Honor. FERC has the discretion to impose those conditions. However, the purpose of those conditions was not to get around the need for a water quality certification. If this court were to permit these interim conditions to go forward without a water quality certification requirement, it would allow any company going forward on an annual license to make these changes during the annual license process, knowing that it could get around any state certification requirements. And by the time Vandalia is able to exercise its right to give a water quality certification on the new long-term operating license, those changes would already be in place. Therefore, because these changes are a discharge and a material adverse impact under the Clean Water Act and Federal Power Act, this court should reject FERC's findings and hold that a new state certification is needed.
Is there a mechanism by which an agency like FERC and an agency like EPA can get together and decide what particular issues one can decide as opposed to another? Has there ever been any discussion of that in case law?
My case law research did not reflect anything, Your Honor, but that is the purpose of this water quality certification, to give the state's environmental board and environmental agencies, I see my time is up, Your Honor, may I briefly? To give the states and environmental boards the chance to weigh in and balance environmental concerns with the licensing and operation of hydroelectric plants.
Okay. Thank you, Ms. Kokelka. And Ms. Olson?
Mr. Chief Justice, Your Honors, Counsel, may it please the Court. My name is Kendra Olson, and I am here today representing Commonwealth Energy as the respondent in this portion of the consolidated action. And it is CE's position that the FERC was correct when it found, first, that the amendments to the Eagle Hydro Station do not create a need for a new water quality certification, and second, that the issuance of an annual license was properly completed by the FERC, because annual licenses are a non-discretionary act and cannot be conditioned on state certifications.
Ms. Olson, would you respond to the comment made by your opponent a few moments ago that the EPA and the states would be in a better position to address the particular issue that was before and that was discussed among other judges?
Well, Your Honor, this Court is faced with a very complex licensing scheme for certain, and it is CE's position that the FERC, as the administrator of licenses and being charged with licensing under the Federal Power Act, and seeing that a hydro station is primarily a producer of electricity rather than a function of the Environmental Protection Agency, that it is appropriately found under the Federal Power Act.
Doesn't your answer just actually make your opponent's case? Because what your opponent's saying is, sure, FERC's got its interest in this, and it can veto it by not providing a license, but there's a separate environmental interest. And the only way that they get a seat at the table is if they have the opportunity to perform the water quality analysis. And if FERC says no, that we're going to just say that's not important, then they have no seat at the table. And isn't that contrary to the whole statutory scheme that gives the federal government a piece of the regulation and the state government a piece of the regulation?
With all due respect, Your Honor, Commonwealth Energy doesn't see it that way. The state of Vandalia has its opportunity to administer its water quality standards. But then after those water quality standards have been submitted to the FERC for interpretation and for implementation, it is in the Federal Power Act and in the Federal Energy Regulatory Commission that the best analysis of what actions need to be taken going forward should be. So although the Environmental Protection Agency and the state environmental boards certainly have expertise in an area of environmental law, the FERC also has a strong expertise in the area of power, in the area of power law and electrical law. And so that in particular is important in this case because...
Is it important enough that we should give them Chevron deference?
The FERC is entitled to Chevron deference when it is interpreting the Federal Power Act. It is also entitled, when interpreting its own regulations, that they should be that the agency's interpretation of those regulations should be controlling unless they are clearly erroneous.
What about the Clean Water Act?
The Clean Water Act, Commonwealth Energy concedes that cases out of the D.C. Circuit in particular seem to point to a de novo standard of review whenever the FERC is interpreting the Clean Water Act.
Okay.
And there is, Commonwealth Energy has come across no case law that disputes this at this point. In support of its position, Commonwealth Energy will address the following 4 points. First, the amendments to the hydro station do not require a new water quality certification because there is no new discharge created. Second, there is no need for a new water quality certification because the discharge will also not have a materially adverse impact on the environment. And third, the FERC properly issued an annual license with amendments and without conditioning it on water quality certification because the issuance of annual licenses is a non-discretionary act. And finally, the structural amendments were appropriate because the FERC used its discretion and avoided an economic burden on both the people of Vandalia and the people of Franklin.
I don't mean to take this out of order, but could you explain how exactly the issuance of an annual license is a non-discretionary act?
Absolutely, Your Honor. Under 16 U.S. Code 808A1, the language dictates that the FERC shall issue from year to year an annual license to the then licensee. And this language has been taken by both California Trout out of the Ninth Circuit as well as Hoopa Valley Tribe versus the FERC out of the D.C. Circuit to mean that the FERC has no discretion to deny an annual license. And this is an important stopgap measure because it applies only to utilities that have been previously operating under a permanent license.
But if your interpretation were correct, then all an enterprise and utility would have to do is apply every year for an annual license, and the original grant of the license could never be modified or challenged. That can't be right.
Isn't it true that the original license is currently under review by at this time, and that this is the stopgap measure by the FERC in the meantime, and that actually the delay in the license might have been Vandalia's fault?
Yes, Your Honor. The annual license is an important measure. Commonwealth Energy is not aware of whether there is a ban on how many times that license can be applied to because Commonwealth Energy has no intention to continue applying for annual licenses. Indeed, their next 30-year license is
That's what you're saying, but isn't if we allowed this, isn't it conceivable that some other energy company could take the same tack and just ask for an annual license renewal?
Your Honor, I am unaware of any statutory provision within the Federal Power Act that would prevent such an action. However, it seems that the FERC, in its discretion, would have to investigate such actions on its own.
So it is discretionary, right?
Whether or not the license could be denied on the continued reapplication for an annual license, to that point, Your Honor, I am afraid that I cannot speak. However, all case law at this point speaks to the fact that annual licenses must be issued to an entity that was previously operating under a license. The part that becomes discretionary for the FERC is whether or not amendments can be made to that annual license. And under 18 CFR 16.18d, the FERC reserves the right to incorporate additional or revised conditions to annual operating licenses. And this kind of discretionary act is again in place to ensure that when the circumstances dictate that it is appropriate to make amendments to annual licenses, like it is in this case, that the FERC has the ability to do that. In this case, Commonwealth Energy has been operating the Eagle Hydro Station since 2008 with one of the two turbines malfunctioning and leaking. And so it stands to reason that in cases where amendments are appropriate because there are problems with the operation of the station, that you can, it's clear to see why this kind of amendment is appropriate.
Whose fault is it that it's malfunctioning?
Well, Your Honors, the problem is that repeated attempts have been made to repair the broken turbine. However, the the ultimate problem is that it is old and needs to be replaced, and it cannot be replaced until revised conditions are issued from the FERC. Your Honors, in addition, there will not be a new discharge created by these amendments to the hydropower station. And this is true for two reasons. First, since the Eagle Hydro Station is a facility that has been in operation for some time, there's an existing discharge already in place. And an existing discharge cannot possibly be a new discharge. A new discharge can be created. It is possible to create a new discharge when the condition, or I'm sorry, when modifications or alterations to a discharge reach a certain level. And opposing counsel properly pointed out Alabama Rivers Alliance. However, Alabama Rivers Alliance was not addressing the precise conditions that we are seeing today. Alabama Rivers Alliance, they were replacing 3 out of the 4 turbines that were in place at that hydro station. But the court took pains to note that it was not because of the structural modifications or the structural upgrades to the plant that there would be a need for a new water quality certification. Rather, it was because the flow rates would be drastically different from what they were under the previous license. Similarly, in state of North Carolina versus the FERC, an annual license in that case, or I'm sorry, amendments were granted because there was a finding by the court that the discharge would be ultimately the same, or rather the intake would be less than it was previously. The existence of these certification rights, though, under whether determining a discharge is altered or whether it is new, certification rights do not vest unless there is a new discharge, and there is no new additional pollutant, as the opposing counsel has mentioned. Turning to S.D. Warren and Company versus the Maine Board of Environmental Protection, the court there turned to the Clean Water Act's definition of a pollutant, which includes a man-made or man-induced alteration of the physical or chemical properties of water in this case. And there is no actual man-made or man-induced alteration of the water. Rather, the water enters the station as it is and exits as it is also.
I thought the statute says may result in any discharge. Where is the word new in that statute?
That's correct, Your Honor. The interpretation that may result in a discharge, that phrase, has been interpreted by the Ninth Circuit in Alabama Rivers as well as the state of North Carolina to mean a new discharge. However,
The Supreme Court has not spoken to that.
no, Your Honor, the Supreme Court has not addressed that issue.
And I mean, you don't dispute that there is a discharge here. Your argument is that it's an old discharge and it's the same discharge.
That's correct, Your Honor.
What about the point that there is going to be a change in the water temperature? You don't dispute that that change will exist, right?
No, Your Honor.
So how is that not a new discharge? Or at least it changes the quality of the discharge, doesn't it?
Precisely, Your Honor. But as the court stated in State of North Carolina v. FERC, certification rights under Section 401 of the Clean Water Act do not depend on whether a discharge may be altered. Rather, certification rights vest only if a new discharge may occur.
But a discharge with dramatically different environmental effects, why shouldn't that be considered a new discharge?
Well, Your Honor, Commonwealth Energy would dispute dramatically different environmental effects. There will be a change in the temperature. However, the FERC has found that that change in the temperature will actually be beneficial to certain fish species within the river. And so it is a dramatic...
But less beneficial to certain human people.
Less beneficial to people who don't like cold water, perhaps, Your Honor.
What does the record show on that fact?
Your Honor, the record is silent as to, there's no evidence presented by Vandalia or statistics or any supporting evidence that the colder discharge will be detrimental to the recreational or economic.
So your argument is since FERC found for you that they found that you met your burden and Vandalia didn't present anything to overcome it.
Yes, Your Honor, and an agency's finding of facts should only be overturned by a court if they're found, an agency's findings of facts should only be supplanted if they're clearly erroneous or cannot possibly be based on fact. In Arkansas v. Oklahoma, that court found that a court should not supplant an agency's findings merely by identifying alternative findings which could be supported by facts. So although perhaps the state of Vandalia would point this court in saying that the designated uses and that the recreational aspects of the river could be detrimental, a court should not overturn the agency's findings on that matter. And finally, Your Honors, this Commonwealth Energy has presented its evidence to the FERC, and the FERC has found that this change in the discharge will be, if anything, beneficial to the fish species in the river. And Commonwealth Energy poses that it will not create a new discharge or a discharge that will have a material adverse impact on the environment. And further, Your Honors, the annual license was properly issued because the FERC took into account all of the circumstances presented. And therefore, Commonwealth Energy respectfully asks this court to affirm the findings of the FERC. Thank you.
Thank you, Ms. Olson. And I don't believe that Vandalia reserved any time for rebuttal, did you?
Okay. Should we?
Do you want the opportunity for a minute of rebuttal?
Absolutely.
Okay. Is that okay? You don't, no objection? Without objection. You may rebut without objection.
May it please the Court. Your Honor, Vandalia has but two brief points on rebuttal. Commonwealth Energy relies on the alteration versus new discharge distinction that comes from the state of North Carolina versus FERC case from the D.C. Circuit. However, the Supreme Court has since defined the term discharge and did not rely on any distinction between a new or altered discharge, but rather kept the term discharge as broad as possible. Applying this principle that only a new discharge would require a state certification would allow a company to continue to release anything into the water, but so long as it was the same quantity, same rate and flow, the quality of that water would not be at issue. And this is not in keeping with the policies of the Clean Water Act. Additionally, the Winnipenny River flows for thousands of miles, and not allowing Vandalia to regulate this water quality, as Vandalia is the only state which is able to issue a water quality certification, would affect the water quality in all of that area. And for these reasons, the state of Vandalia respectfully requests that this court overturn FERC's determination and hold that a new state certification is needed. Thank you.
We thank counsel, all counsel, on both sides of both cases for excellent argument. And at this time, the court will take the matter under advisement.
All rise.